Dear Mr. Carlton Sitek, Head of the Economic and Trade Sections from UI Delegation to Vietnam, dear Mr. Trần Lê Hồng, Deputy Director General of IP Officials Vietnam, and dear of our distinguished delegates, I'm very honored to be here today to share my presentations regarding the patents and industrial design under the revised IP law. In order to save some time, I would like to go straight into my presentations. So there are four main parts in my speaking today. First of all is the overview of revised law on inventions of patents and industrial design. The second point is revised law on patent protections. The third part is revised law on protections of industrial design. And the fourth part is revised law on procedure generally applicable to patents and industrial design. In terms of revised IP law, as you've already know, during the recent times, Vietnam has some revised IP law. The first one is law amending and supplementing a number of articles in the IP law. And this is one of the critical documents of Vietnam. Is the law number 7, 2022, QH15, took effect from the 1st of January 2023. The second one is decree number 65, 2023, NDCP from 23rd of August 2022. And this one detailing a number of articles and measures to implement the IP law on industrial property. And next one, we have circular number 23, dated from November 2023. So these are three main documents regulating certain points in terms of patents and industrial design protections. And to go into further details, as I mentioned, these documents are critical in the IP law systems of Vietnam. And when amending and supplementing these documents, Vietnam has issued 7 main regulations. And all of these documents need to follow these 7 main policy. And the first policy is to encourage the creations, exploitations, and dissemination of patents, industrial design, and layout design created from science and technology using the state budgets. And this is one of the important policy in this revised IP law. And the second policy is to create favorable condition for a process of implementing procedure for establishing industrial property rights. As you know, the whole process includes very detailed steps, all the way from submit the application to conducting the substantive examination. So in order to create favorable condition for the applicant and also to promote creativity and innovations, in this amendment, there are many new point to create this condition for the applicants. And later in my presentations, I will go through in more details. And the third policy is to ensure a satisfactory level of protections and balance in protecting IP rights. In addition to promoting creativity and innovations by encouraging the applicants, there's another important mission, which is we need to balance between the rights of the owners and also of the public. So these are two pillars that we need to always balance. We cannot just only focus on the rights of the owners while neglecting the right of the public. We need to harmonize these two rights. And the fourth policy is to ensure full and serious implementations of Vietnam's international commitments on IP protections. As Mr. Carsten also mentioned, the EVFTA. So in addition to that, Vietnam also participates in CCTPP and also other agreements which outline Vietnam's commitment in implementations, the agreements. So this is one of the big policy and important ones which we need to pay attention to. So these are 4 major policy I would like to present to all of our participants today. And next part is the regulations on patent and industrial design in the revised IP law. So for the IP Law 2022, the amendments and supplements is related to protection conditions, establishment of rights, owners, contents, and limitation of rights for patent and industrial design. So in order for this law to be effective, we need to have additional decree, and in this case, it's Decree 65/2023 NDCP, which include new regulation to carry out a tax assigned by the law, i.e., handling confidential patent applications. And also, we have regulations inherited and revised from Decree number 103 from 2006. We also have regulation containing administrative procedure posted from Circular number 1, 2007. Other regulation to internalize international treaties like the Hague Agreement. We also have a huge set of appendix, including registration form, specific requirement for each applications, and all of these documents partly are brought from Circular number 1, 2007, with some technical corrections or new drafts. And in terms of Circular number 23, it includes new regulation to carry out tax aside from the law, as well as regulation inherited and revived from Circular number 1, and regulation to internalize international treaty, the Budapest Treaty. And in this circular, the appendix only has one new registration form on using foreign patent substantive examination result. And now I would like to go into a bit details on patent protections. As I listed in this table, we have 13 main regulations related to patent protections, together with some minor supplement or amendments, which you can refer to the IP law itself. So on here, I just only listed some main amendments in terms of content, not only technical. So the first one is the novelty of patents. It is in Article 60 of the IP law. So there is one additional content, which is the novelty of patents. So the patent is deemed novel if is following or is under certain case. And there is an amendment. It's Circular 23 in order to be compliant with these articles. So when we consider the novelty of a patent, we need to consider the date of filing applications. So during the examination process, we need to consider the priority in terms of the filing date when it is submitted to the registration office. So that's for the first part. The second part is the right to register for patent. So the register for patents of individuals and organizations relating to origins of genetic. And there is one additions. As you can see on the screen, the blue part is the additional contents. So it is related to organizations or individuals who have invested funds and material facility or being assigned to manage genetic resources. And the third part is related to requirement for patent applications. It's supplementing provisions in Article 100 of the IP law. So it's saying that documents explaining the original of genetic resources of traditional knowledge associated with genetic resources in the applications for registration of inventions. Invention directly created based on genetic resources or traditional associated with genetic resources. And I think with this one, Vietnam is actually way ahead of certain countries. And actually, WIPO also approve certain documents, and in there, it is also stated certain clause or point related to origins of genetic resources. And requirement for the registration form. So in the past, as you already know, in this appendix is in circular number 1. But at the moment, it's no longer there. So it is pushed forward in the resolutions. And in terms of the registration form, we have general requirements for the form itself and also specific requirements. And next one is Article 14 of Circular 23. There are some technical amendments and also related to internalized international treaty, Budapest Treaty. It also regulates on the limit and document to verify information in the application in case the NOIP has ground to doubt the authenticity of the informations. So for this one, everyone can refer to the IP law documents for more information. And the next part is security control for patents. This one is actually an important part in the application process. So there are supplements in Article 89A of the IP law on security control. So for inventions in technical sectors which have an impact on national defense or security are created in Vietnam and under other registration right. If it has been filed in Vietnam for security controls, actually this is not a new one, but because in the previous resolution we had some point regarding security control. However, this need to be legalized in order for it to be enforced effectively. So in the resolutions, the patents under any fields, any industry, while being filed in Vietnam and before filings abroad, is need to go through the security control process. But actually, in this amendment, it creates more favorable conditions for applicant, and also it mentions clause regarding locations and times of filing the applications. So these amendments actually are creating much more favorable conditions for applicant to save times. And also, the government shall details clause 1 of this article. There are also transitional provisions in the IP law for patent applications, which are here in the slide. So in Decree 65/2023 NDCP, is outlined the patent security control order and procedures. So in Article 14, which is a very long one, I would like to summarize it as follow. So when receiving applications, notifying that I have the intention to submit this patent abroad, the IP office in Vietnam will consider whether it will be related to national defense or any related in the public security areas. And then the relevant department will act upon after examinations and also send relevant notice to the applicant. And if receiving a response from the Ministry of Public Security and National Defense, which is saying that this one is containing confidential contents and related to the national defense. The applicant must submit an inventions application according to procedures in accordance with the provisions of law on protections of state secret within 1 month. Otherwise, the application must be considered withdrawn. And if the response from the Ministry of Public Security and National Defense saying that this is not related to state secret, so in that case, these applications will be continue with the normal examinations, and the applicant will be notified. And also there is Appendix 7, list of technical fields that impact security and national defense. For example, patents related to weapons include ammunitions, chemical, biological, nuclear weapons, and other weapons used in military use, explosive materials, military equipment and technology used for intelligence, counterintelligence, and criminal investigation activity. This is actually quite broad. However, the fact that we have this list of technical fields, which was listed by the Ministry of National Defense and Public Security after careful considerations, and it is in accordance with Vietnam's current law related to state secret. And the next part is confidential inventions or patents. So when we identify an invention, it's deemed confidential. It must be processed according to a different process. And in the revised IP law, it's adding clause 12A, Article 4 of the IP law on the definitions of confidential inventions. So confidential invention means an invention identified as a state secret by a competent agency or organization in accordance with the law on protection of state secret. And it's also added clause 3, Article 108 on the IP law. And also it also includes in the Decree 65, Chapter 4, Article 48 to 52. For example, confidential invention must be submitted in paper form, and it needs to be attached with documents certifying that the registered object is a state secret. Complaint procedure of the confidential inventions is not applied, and do not publish applications and decrees in the official gazette. And is need to offshore registration requires approval from the Ministry of Public Security and Ministry of National Defense. So that's some information related to the confidential inventions. And the sixth part is about formal examinations of patents application. So this one, supplementing provisions in Article 109 of the IP law, and added a case of refusing to accept a valid application if the patent application is submitted contrary to the regulations on security control, which is related to the previous point I just mentioned. In terms of substantive examinations of patent application, this is not something new, but it just legalized previous regulation. So it's supplementing provisions in clauses 4 and 5, and which has been stated in certain circular in the past, but this time it has been legalized. And regulation on how to process the substantive examinations. And in Circular 23, will and in Clause 16 of the Circular 23 will stipulating procedure for using results of substantive examinations. And in Resolution or Decree 65, there's new point in Clause 4 regarding handling requests for examinations of the content of patent application requested by a third party. So in the past, there is no detailed regulations or procedures on this part. And in the Decree 65, there are new points for handling requests from a third party. So it's all stated in the Decree 65, which everyone can refer to. And number 8 is refusal to grant the protection title. In Article 117 of the IP law, is supplementing certain point in refusal to grant protection titles. For example, the applicant is not entitled to register, or the amendment or supplement of an application expand the scope of objects disclosed or stated in the applications, or change the nature of the objects of registrations. Number 9 is cancellations of effectiveness for protection titles. There are certain amendments and supplements in the IP law, Article 96. As you know, there are only 2 cancellation cases in the previous law. In the case where the applicant is not entitled to register, but based on the premises, it's actually not enough to ensure that we balance the information to have the exclusive right to use that protection titles. So in the revised IP law, it edits cases and grounds for cancellation. So first of all, in case the protection title will be entirely cancelled, if the application for registration of inventions is failed, contrary to the regulations on security control specified in Article 89A of this law. And also, it added certain cases when the cancellation is partially or in whole, including the amendment or supplements when it is expand the scope of objects disclosed or stated in the applications, or change the natures of the objects of registration as stated in the applications. So these are some new points which were added in the revised IP law. And it is in Article 96. It also stated that a protection title shall be partly or wholly cancelled if a part or the whole of which fails to satisfy the provisions of this law on registration right. And these are some newly added points which everyone can refer to in the revised IP law. And number 10 is processing PCT applications. In Decree 65, Article 3, Clause 19, 20, 21, amends and supplements regulations. Actually, it's not new one, but it's inherited certain point from Decree 103, as well as Circular 1, 2007, plus some certain amendment in terms of technical points. And of course, it also includes some certain new point. So, for example, the regulations are the same for application designating Vietnam and application selecting Vietnam. So, combine into PCT applications in the national phase, and supplementing regulations on determining whether the subject matter requested for protections of a PCT applications of Vietnam's origins submitted to the department, whether it is a state secret or not. And number 11 is compensation to invention owners for delay in licensing the circulation of pharmaceutical products. So supplementing provisions in Article 131A of the IP law. So the patent holder is not required to pay a fee to use protection title for the period which the registration of initial circulations of pharmaceutical products manufactured under such patent in Vietnam is delayed. And in certain countries, they will increase the time limit for protection title. However, in Vietnam, upon considerations of a certain international treaty which Vietnam is a part of, and under Vietnam's capability, Vietnam has selected or has decided to compensate in case compensate by not requiring the patent holder to pay the fee. And other details clause is stated in clause 42, decree 65. And number 12 is the grounds for compulsory transfer of inventions use rights. This one supplements provisions in Article 145 of IP law. And it says that the use of invention to meet the needs of pharmaceutical for disease prevention and treatment of other countries that are eligible for import according to international treaties. So in the past, in the case where where a mandate transfer invention use right is required, with current condition of Vietnam, the amendments of the decree in the revised IP law, they have added certain ground to implement and enforce this right. And in Article 146, the right to use an invention is transferred by decision of a competent state agency. The license of the right to use must pay the holder of the exclusive right and suitable compensations. So these are the regulations in order to implement the international treaty. So those are 13 content related to patent applications, which amendment and supplement from the decrees and the regulations. So the next part is in regard to protection of industrial designs. There are less contents. There's only 7 regarding to interpretations of the terms, requirement for applications or announcement of applications, etc. So the first amendment is in relation to interpretation of terms in clause 13, article 4. And this is in accordance with the commitments of the EVFTA's agreement, which Vietnam has signed. So industrial design means the external appearance of a product or part for assembly into a complex product, represented by shapes, lines, color, or a combination of these elements, and visible in the process of exploiting the utility of product or a complex product. And there is transitional regulations from the 1st August 2020, and this is also the day which the EVFTA agreement took effect in Vietnam. So this is also show the commitment of the international agreement with Vietnam has signed. And the next one is requirement for industrial design applications. This one is actually quite new, going towards simplifying the process for the applicant to promote creativity and innovations. So in the applications, documents determine the industrial design will include a set of photos and drawings of industrial design, plus the descriptions of industrial design shown in a set of photos and drawing. And these material must fully demonstrate the design features. And it's actually quite simple. You need to list in order the set of photos and drawings and any other details. So this slide actually I copy exactly from the IP law as well as the amendment and supplement. As you can see, the removal is actually quite a lot, and there's only a few content left in the requirements for industrial design applications. So in Appendix 1, Decree 65, it specifies Article 103 of the IP law for the description of industrial design. And number 3 is publicity for applications. So this is for when Vietnam joined the Hague Agreement. And it says that application for registration of industrial design shall not be more than 7 months from the filing date. And in accordance with that, the registration form according to Appendix 1 are also amended, adding the section request for late publications, and the applicant can tick in this part. So these are the newly added points. The next part is refuse to grant industrial design protection title. And similar to cancellations, in this case, the applicant does not have the right to register in industrial design, or amendment and supplement to the industrial design expand the scope of objects. And the next one is effectiveness of protection title. Is amended and supplemented Article 93 of the IP law. And according to the Hague Agreement, the time's limitations will be following the end of the 6-month period from the date of announcements by the International Trade Office. So in the past, when Vietnam hasn't joined the Hague Agreement, this one was actually quite different. And since joining the Hague Agreement, there is more interpretations in terms of terms, and it's stating or clearly identify Hague applications, whether it's origin from Vietnam or any other countries. So there are some of the summary in Decree 65. For example, it needed to be in English, or the processing of the applications, or Hague application originating from Vietnam, for example. And other cases, whether it's containing errors or not. In the cases when the application originating from Vietnam, everyone can please refer to Article 24. So in the Article 121 of the IP law, it's saying that owner of inventions is an organization or individual that has been granted a protection title by a competent authority for respective industrial property objects. And this is in accordance with other regulations since Vietnam has joined the Hague Agreement. And the fourth part is new regulations on procedures of general application for inventions and industrial design, which includes 6 parts. And the first one is the right to register design and invention and industrial design is the result of the science and technology mission using the state budgets. And this is actually showing a new and open thinking and strategy of Vietnamese government. So as you can see, invention and industrial design is the result of the science and technology mission using the state budgets. So we have two cases: industrial design, which is not not a state secret, and it will be assigned to elite organizations, not the organizations who are granting the budget. So the lead organizations is the one who directly created or invented that design, industrial design, and also learning from the Biden Act of America. The revised IP law has actually added some new point as shown on the slide. For example, Article 86A or Article 43, 44, 45. So if the lead organizations chose not to use that right to register, they can transfer that applications for other organizations. However, this organization need to be those established under Vietnamese law or individual who is a Vietnamese citizen or permanently resides in Vietnam. So if the lead organization doesn't have the need to register for it, the organizations who are authorized by the Vietnamese government can register for this patent. So there are three different organizations here, which is the transferee, or another suitable organizations who is meeting the regulated requirement. So these are quite important points. It also says that for patent and industrial design in the field of defense and national security, the right to register will belong to the state, with the right corresponding to the investment ratio of the state budget. So this regulation is mandated in clause 43. And in the registration form, for those of you who have used this form, you can see there is supplement in the yellow part, which is saying that the right to register invention and industrial design is the result of science and technology mission using the state budget. In terms of priority rights of invention and industrial design application, it's clearly stated that the first application filed in Vietnam or in a member country of the Paris Conventions is eligible to enjoy priority rights regardless of the processing result. So when it is filed, the priority date can be considered regardless of the processing result. And in terms of the third person opinions, objecting the applications, this is a newly part. So this is to separating two process. So the first one is stating that the opinion of a third party is considered a source of reference informations, and the other part is the opinion of a third party, which is objections to their applications. So for industrial design, it is 4 months from the day on which the applications is filed, and for invention is 9 months from the day on which the applications is filed. In terms of the orders to process the applications, there are different processing order, which everyone, because of limited time, I would not go into too details. So in Degree 65, Article 16, there are amendments in terms of amendments and supplement scope. There are two different cases relating to filing process. The first one is the application registrations extend the scope of protections disclosed in the descriptions, and it is amended before having the decision to refuse or accept the applications. So in these two cases, each case will have a different order and procedures. And the next part is split application, withdrawal applications, and transfer applications. This is in order to simplify and make the application process much more transparent, as well as helping the IP office in the making decision process. And number 6 is grant a protection title. And this is also some newly added contents in Article 118 with regulations on granting protection title to all or parts that meet protection conditions. So in Article 118, Clause 1, where an application for industrial property does not fall into the case of refusal, that's mandated in Clause 1, 1A, and 2. And this is the procedure that I have summarized in order for everyone to understand this easily, because when you look at the document, it might be a little bit complicated together with complicated terms and words. So in this slide, I have summarized it, and hopefully it will help everyone in understanding the contents. And that's the end of my presentation today in regard to revised IP law on patent and industrial design. Thank you very much, everyone, for your attention.